Good afternoon. I'm Dan DeRosa with 19 News, coming to you from our digital desk. We're about to take you to a sentencing down in Akron. Now, this is a really interesting and actually an albeit sad case. That man you see sitting there is Demonte Sherrod. Now, he and his friend Mario Harris were in a stolen vehicle back in 2016 in Akron when that man, Demonte, started playing with a gun. That gun went off and shot his friend. His friend would be paralyzed and suffer severe brain damage. Demonte was sentenced in 2017. He pleaded no contest to felony assault and receiving stolen property. But the problem was the severe injuries to Mario Harris. He would end up dying. He actually died in 2024 from those injuries. So now that young man is being sentenced for, he's pleaded guilty to involuntary manslaughter. It looks like we're about to hear from Mario Harris's mother.
I will not be saying my statement today. The person that got my statement is the only person that needs to hear my statement. But I will be saying no matter what the outcome is today, it will not define my son's character, legacy, nor his memory. Thank you.
Thank you very much, ma'am.
Thank you, Your Honor. Your Honor, Mario Harris was a mere 19 years old when his life was changed for forever. It's been several years since he was injured, and the life he led after he was shot was completely different than the life he had been living. He needed around-the-clock care. He had significant brain injury, paralysis. He was considered a quadriplegic. And he continued to have extreme respiratory issues. The state argues that his quality of life was diminished to almost zero. Recently, Mario lost his battle and lost his life, which is why the state went back and re-indicted this case. The defendant's pled to involuntary manslaughter. The state has submitted our analysis of some of the issues that the court had addressed at our plea. If the court finds that involuntary manslaughter and felonious assault are allied offenses, the state is just asking to elect to have the defendant sentenced on involuntary manslaughter, and we're asking for the max. This is a young man who did absolutely nothing that day, other than be in the car with the defendant. Playing with a gun will always have serious consequences, and that's what happened here.
Thank you. Mr.
Thank you, Judge. On behalf of Mr. Sherrod, I guess I'd like to start by noting that we have filed a sentencing memorandum. I think that's relatively comprehensive with respect to the issues of merger, the issues of Reagan Tokes, and what we think is appropriate in this matter. I'll get to that in just one moment. I just want to remind the court, obviously, of the 29.11a factors and purposes of felony sentencing, and just to quote those out loud, it's to consider the need for incapacitation, deterrence, rehabilitation of the offender. Sentences, furthermore, should be commensurate with and not demeaning to the seriousness of the offender's conduct. I say that, Judge, because Demonte Sherrod's already been sentenced once for the actions that we are here for today. Back in 2017, after pleading no contest to 2 counts of felonious assault and 2 firearms investigations, he was given an aggregate sentence of 8.5 years in prison. Demonte served every day of that 8.5-year sentence. He was released, and within a month, he was rearrested on the supplemental indictment in this case. Mr. Sherrod was out for a little bit of time, but he's essentially served an additional 220 plus days, bringing his total amount of incarceration, Judge, to 9 years of jail and prison with respect to this offense. I want to start by addressing the issue of Reagan Tokes. At the plea hearing, there was unclear, based on the language in the indictment, whether Reagan Tokes should apply. I submit to the court that it does not, and I think that it's a relatively simple analysis. The statute regarding Reagan Tokes requires that the offense be committed on or after March 19th of 2019. This offense was committed in July of 2016, 3 years before the enactment, passage, or even introduction of the Reagan Tokes law. The only conduct for which Mr. Sherrod is being sentenced today is the conduct that occurred on July 30th of 2016. I don't believe that it's a qualifying offense. I don't believe that Reagan Tokes applies. But if this court deemed that it was an offense that was committed after the passage of the Reagan-Tokes law, I would suggest to the court that it is still an ex post facto law and would be prohibited under Article 1, Section 9 of the Ohio Constitution. So with respect to Reagan-Tokes, Your Honor, I think that answer is relatively clear, and that's my position. With respect to the issues of merger and jail time credit, I guess what I want to clarify here is we agree that based on the plea from just a couple of weeks ago, the sentencing range available to this court is 3 years to 11 years on the felony one involuntary manslaughter and 3 years on firearm specification for a range of 6 to 14 years. As I've already outlined, DeMonte served 9 of those years, including a firearm specification. And I bring that up because I do not believe that this court has the authority to order DeMonte to serve another firearm specification. And the reason I'm suggesting that, Your Honor, is on the plea form from 2017, there are 2 counts of felonious assault with 2 3-year firearm specs. And Your Honor imposed that 8.5-year sentence on DeMonte at that time with a firearm spec already attached to it. So adding an additional spec now would essentially treat this as a 3rd firearm spec to which he's exposed. I explored some of that case law in the memo, and I won't belabor the point here today, Your Honor, but it's safe to say I believe that he has served that firearm spec in its entirety. So the question left for us to determine today, Judge, is between that 3 and 11 years on the underlying F1, how much time should you give Mr. Sherrod? And I want to remind the court and reiterate that you're not sentencing 25-year-old DeMonte. You're sentencing a 16-year-old kid who made a stupid decision to play with a gun in the car with his friend. And I would suggest to the court that the sentence that was previously imposed in 2017 is commensurate with the outcome of the actions that happened on that day. In fact, Your Honor, the plea form back in 2017, I think, speaks to that, and I'm just going to read it out loud. You know, the original agreement on this no contest of the felonious was plead the indictment, no contest, no deals. State is free to argue. State also reserves the right to file additional murder charges if it becomes appropriate. And I would suggest to the court that it was contemplated by all the parties back in 2017 that this outcome of Mr. Harris was inevitable. And that doesn't make it any less sad. It doesn't make it any less tragic. But it also doesn't increase what an appropriate sentence would be for DeMonte. I don't disagree with anything the state said about Mario Harris. It was DeMonte's friend. We submitted letters to this, speak to that friendship back in the day. And while I don't want in any way to diminish how Mario's family feels, DeMonte's also had to live with that for the entire time that he's been arrested. So, Your Honor, based on the information that we presented to the court, based on the fact that you're really sentencing DeMonte, the 16-year-old, not DeMonte, the 25-year-old man, I'm going to ask you to give him credit for time served. That would be 9 years and approximately 2 months that he served for this offense. I don't believe that sentence would diminish the seriousness of the offense. And I don't believe that it would, I guess what I would say is adding additional time, I don't think would improve any of the purposes of the principles of sentencing. Finally, just the last couple of points, Your Honor. We did submit letters on behalf of DeMonte, and I understand that the court was given a letter today regarding the fact that Mr. Sherrod does have employment available if and when he is released from custody. That's notable only because when he was out on bond in the beginning of this case, DeMonte did do a good job of immediately getting employment, and he maintained that employment up until his bond was revoked. So I just want that to be known as well. Finally, Your Honor, Mr. Sherrod did engage in programming while he was in the DRC. We did submit certificates and the proof that he completed his GED while he was incarcerated. Thank you.
Thank you. Mr. Sherrod, is there any statement you'd like to make to the court before sentencing?
Yes, Your Honor. First and foremost, if I may, I want to apologize to you, Ms. Robin, from the bottom of my heart. You know what I'm saying? Mario has never been nothing but a brother to me. And this situation was wholly unintentional. You know what I mean? If I could take it back to that day, I would have never even gotten in the car or allowed Mario to get in the car with me for this thing to be brought about. And I just pray one day that from the bottom of my heart, you just honestly forgive me for this even coming about. Your Honor, I would also like to say to you that I'm not the same 15-year-old kid that you ordered time to serve 9 years ago. Every day that I sat in prison, I've been reflecting on this and how many lives this affected. With the time that you gave me, I tried to do as best as I could, you know, never being in this situation ever in my life, to just adapt to the circumstances and come out with a different outset on life than what I previously had. I just want to say, you know what I'm saying, I hope you have mercy on me in declaring this judgment today.
Thank you. You wouldn't believe that this was 9 years ago. One might hope that gun violence in our community would have gotten better instead of worse. We still have today juveniles carrying firearms and committing offenses with firearms. Mr. Schrod always knew that there was a possibility that he could be indicted in the future for the death of Mr. Harris. That was brought up numerous times in 2016 and at the time of his plea because of the physical condition that Mr. Harris was in. To his mother, I want to say, not only having your child shot, but caring for him in such a manner for the last 9 years, I'm sure took extreme emotional toll on you. I have read every letter that was submitted to this court. I understand the devastating effect that this has on both families. I have reviewed both sentencing memorandums, and I will start with this issue. Reagan-Tokes was passed on March 22nd of 2019, in which it clearly indicated that this law would not, the sentencing law would not be applied retroactively. There's criminal activity that can span prior and post Reagan-Tokes, excuse me. The ongoing mental mens rea that you must have to commit a criminal offense could actually traverse both of those dates. The actual shooting that ultimately resulted in Mr. Harris's life occurred in 2016. It occurred prior to the enactment of Reagan-Tokes. And while the end result of that criminal activity may have happened post Reagan-Tokes, I do find that the sentencing ranges for a definite sentence on a felony 1 applies in this case, and that Reagan-Tokes does not apply to this offense. With regards to the firearm specification, furthermore, I do find that the arguments of Mr. Will, as well as the law at the time under 2929-14D1B, prohibited a court from imposing more than one term for multiple firearm specifications that involve the same act or transaction. With regards to the involuntary manslaughter and the fact that it's based on an improper handling of a firearm in a motor vehicle, while the elements may be different, that is not the only consideration the court must make in determining the merger analysis. Pursuant to 2941.25 of the Ohio Revised Code, as well as State versus Johnson and State versus Ruff, I must consider whether these offenses are allied offenses of similar import. In making that decision, I must determine and consider the conduct, the animus, and the import. The offenses do not merge if any one of the following is true. The conduct constitutes an offense of dissimilar import. The conduct shows that the offenses were committed separately, or the conduct shows that the offenses were committed with a separate animus. Furthermore, the offenses are of dissimilar import because the harm that resulted in each offense is separate and identifiable. Based on those standards and the case law that exists regarding merger, I do find that the felonious assault, the 2 counts of felonious assault and the involuntary manslaughter, regardless of the fact that it's based on an improper handling of a firearm in a motor vehicle, would merge for purposes of sentencing. And therefore, upon that merger, the state would have the ability to pick which offense they want to proceed to sentence on. So at this time, based on representations by Prosecutor Mitchell, and the request to proceed on the sentencing of involuntary manslaughter, a felony of the first degree. I will do so and find that the 2 counts of felonious assault, as well as the firearm specifications, merge for purposes of sentencing pursuant to the law as it existed in 2016. And that the defendant will be convicted of one and only one firearm specification. I have considered the purposes and principles of sentencing pursuant to 2912 of the Ohio Revised Code, and that a prison term is consistent with the purposes and principles of sentencing as set forth in 292911, and that the defendant is not amenable to any community control sanction. While there is no requirement for a mandatory prison sentence on a felony of the first degree, there is a presumption of incarceration. And while I respect the arguments of Mr. Will and the strides that Mr. Sherrod has made while both in custody and initially out of custody, there is some behavior post-release from the Ohio Department of Corrections that indicates that maybe all of those things aren't necessarily true. The defendant's bond was revoked for purposes of violation of my pretrial supervision and conditions. And because of that, he now remains in custody as a result of that. I have determined, therefore, based on the facts and circumstances of this case, in consideration of the relevant sentencing factors applying the minimum sanction I determined, will protect the public and punish the offender without imposing an unnecessary burden on state or local resources. I'm imposing the following. As to the count of voluntary manslaughter, a felony of the first degree, I'm imposing a 10-year prison sentence. As to the felonious assault, which has merged and will be purged from the record as a conviction, and there will be only a conviction showing for manslaughter, voluntary manslaughter, I'm also imposing a 3-year firearm specification. That is a mandatory prison term that must be served consecutive and prior to any term served on the manslaughter charge. I'm also imposing the 6 months on the receiving stolen property for a total of 13 and a half years in the Ohio Department of Corrections. The defendant will be given credit for 8.5 years that he has previously served, as well as 255 days of jail time credit in the Summit County Jail as of today's sentencing date. Again, based on his incarceration, I am waiving the balance of any costs and fees that are due and owing, and upon his release, he will be subjected to 2.5 years of mandatory post-release control, which will be supervision by the Adult Parole Authority. While on that supervision, if he were to violate any conditions of that supervision, the Parole Authority could return him to prison for 9 months for a single violation of that supervision, or up to half of his prison term for all violations. If he is convicted of committing a new felony while on post-release control, the sentencing court could add an additional consecutive prison sentence to any new sentence of 1 year or whatever time remains on his post-release control term, whichever is greater, as an additional consecutive sentence. Because this offense does not carry a mandatory prison sentence, it is possible for Mr. Sherrod to be given credit for a good time of 5 to 15. Well, that will not apply. That's under Reagan talks, so I apologize. I will say this. I know everyone would want me to give him the maximum sentence of 11 years on this manslaughter, because that would just be the easiest thing for this court to do, because ultimately his actions resulted in the death of another human being. But maximum sentences are reserved for those that commit the most heinous offense, a heinous form of the offense. And while some may argue that the death of a person may be the most serious offense, I do find whether or not, however, this event took place in this vehicle, Mr. Sherrod did not run from the police. He attempted to, help his friend, ask people to call for help for his friend, call 911, and that may be an afterthought. But those are things that many people don't do when a crime is committed. Running, fleeing, hiding, none of those things took place. And so because of that, that is the reason why I did not invoke or sentence him to the maximum term of 11 years. Mr. Sherrod, you are entitled to appeal this sentencing. If you choose to appeal this sentencing, you have 30 days from today's date to appeal this sentencing. If you cannot afford to hire an attorney for this appeal, the court will appoint an attorney to represent you for that appeal. Do you understand those rights, sir? Do you wish to appeal this sentence? I'm sorry? Based on Mr. Sherrod's indication that he has no intention of appealing this sentencing, he will be conveyed to the Ohio Department of Corrections to serve the balance of that prison sentence. Anything else on behalf of the state of Ohio?
No, Your Honor.
Mr. Will?
No, Your Honor, thank you.
Thank you. We're adjourned.
Dan DeRosa with 19 News. Really an interesting set of circumstances here, and the sentence for that man, DeMonte Sherrod, he's already served 9 years for being in a stolen car with his friend. He was playing with a gun. That gun then shot his friend, Mario Harris. He serves 9 years for that. He pleads guilty to felony assault, 2 counts, and 2 counts of receiving stolen property, does 9 years. Then you have to fast forward. His friend Mario Harris dies, passes away in 2024 because of his severe paralysis, his brain injury. He needed 24-hour care, and he ends up passing away in 2024. DeMonte had been out of prison for all of a month when his friend died. And so the state had reserved the right to come back if that in fact happened. And apparently, even back in 2017, they knew that the prognosis was not great and that this may end up having to happen. So he comes back and he pleads guilty to involuntary manslaughter. Now, his defense tried to say, Judge, he already served 9 years. Let that be the sentence for all of it. And the state even said, well, he was sentenced on felony assault, but the counts would have merged. That's legalese for when you have a whole list of charges: involuntary manslaughter, felony assault, receiving stolen property. They all kind of merge into one, and you are sentenced on the most serious. So that's what happened here. Is now he was sentenced on the most serious of charges, involuntary manslaughter, to which the judge gave him 13.5 years in prison. You do the math, he's already served 9. That includes the 255 days that he's been in prison and the 255 days he was locked up in Summit County. So you basically, he has to go back and serve 4 more years. And what was interesting there at the end, he did not indicate that he will appeal this. He will go back and serve 4 more years and be done with it and not go through the appeal process. Again, a very interesting set of circumstances we don't see a lot in sentencings. We're going to wrap this up. We'll have complete coverage on this story and all of the day's breaking news, and especially the first alert weather situation. It is a holiday, but unfortunately, Mother Nature is not going to cooperate. There is quite a call for snow Thursday into Friday, and then for everybody on Saturday. Thursday, Friday looks like a lake effect event, but it looks like everybody will get some on Saturday. Not great news for people who are traveling, and we completely understand that. That will be 3.5 hours of news and first alert weather starting at 3 o'clock on Channel 19, as we do every day. Until then, I'm Dan DeRosa with 19 News. Have a good afternoon.